This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate you agreeing to participate, you and your clients agreeing to participate with us via Zoom today. We think it is the best way to keep the wheels of justice turning during this time of pandemic. Both of you, all of you, since there's more than two, are experienced practitioners, so you're well aware of the rules and procedures utilized during appellate oral argument. We will be utilizing those rules and procedures of the Court of Appeals today as if we were standing in the courtroom, so please keep that in mind. Each side will receive 15 minutes to make its oral argument. I understand from Mr. Hibner that rebuttal time has been reserved by the appellant, as well as some agreement as for splitting time in an argument. Before we get started, I want to introduce our panel for today. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Ahmed, Mote, Alzamzami versus Arwa, Al-Sulaihi.
We will hear from the appellant.
Good morning, Your Honors. I'm Attorney Daniel Mikowitz from Memphis, Tennessee, and I am representing the appellant along with my co-counsel, Sam Muldaven. This was our appeal of a divorce granted on a default judgment involving children. The main issues on the appeal was whether the court had proper jurisdiction over the children under the UCCJEA, whether or not a default judgment which was granted should have been set aside, and the award of certain damages and attorney fees and costs. In regards to the jurisdictional issue, it is the appellant's position under UCCJEA that this case was not properly heard in Memphis, Tennessee, and these matters should have been heard in Michigan if that is the proper forum. The issues in the case is the plaintiff, original plaintiff in the case, did reside in Memphis, Tennessee. However, his wife of many years originally resided in Egypt. And she resided in two different countries. She came to America prior to November of 2018, but she came to Tennessee in November of 2018. She resided in Tennessee for less or approximately 4 months. She left Tennessee in February of 2018 and went to Michigan. After she left and went to Michigan, the complaint was filed while she was in Michigan with the children. The original complaint was filed where she had only resided in Tennessee for 4 months, which did not make Tennessee the home state. An initial short hearing was held where the court allowed the children to remain in Michigan, and that was all the first ruling said, is the children can remain in Michigan. A counter complaint was filed on 6/26/18, approximately 4 months after the complaint was filed. And at that point, the children had resided in Michigan for, I believe, 4 months or more, which was equal to or approximately or exceeded the time the children had resided in the state of Tennessee. The first hearing that involved the children was held on 10/10/18, which was 8 months after the children left Tennessee and had begun to reside in Michigan. So when the court entertained its first actual hearing, the children had resided in Michigan for a period of 8 months, twice as long as they'd ever resided in the state of Tennessee.
Let me stop you, counsel. Did one of the parties continue to reside in Tennessee at that point in time?
Yes, the father continued to reside here, but the children have been gone for 8 months.
Okay. Doesn't the law provide that so long as one of the parties remains in the jurisdiction, the court retains jurisdiction?
It retains jurisdiction if it retains jurisdiction over an order, but the only order that had been entered at that time was to allow the children to reside in Michigan. No order as to custody or visitation had been filed at that time. The first order was issued in November, 8 months after the children left. And even that was a temporary order on its own face because it just allowed visitation for a 6-month period. And that order expired on its own after 6 months, other than the fact that the children could remain in Michigan. And also, in order for the court to retain jurisdiction, if only the father lived in the district, the court had to do an analysis at that time to determine whether there was substantial connections with the state of Tennessee. The court did not do that analysis. It merely said, I retain jurisdiction. It did not make a determination based on the statute that there was anything of substantial need to keep this case in Tennessee. In the appellee's brief, they mentioned the children went to school. Well, the children got here in November, right before Christmas break, and they left in February, right after Christmas break. The children had no school records. The children had not been in school any substantial amount of time. The children had no friends. All the witnesses that were involved in this case lived in Michigan. By the time the court had a hearing in November, the children had been there in school for over 6 to 8 months. All the witnesses that testified throughout this case were in Michigan. The family testified at the final hearing, which occurred in 2019, after the husband had left the state. So at that point in time, when the court had its hearing for the default judgment, nobody had been in this state for over a year. And the children at that point had been in Michigan for close to 2 years. Everything was in Michigan, and there was no order to enforce because the only order that was entered by the court said the children could live in Michigan and that father, and it gave father some visitation for 6 months. So there was no visitation order. There was nothing that was active at that time other than the court saying the children could live in Michigan. And to take it one.
Excuse me. Was there a Michigan case pending at that time?
In fact, mother filed a case in Michigan and never got service on father, even though father had been in Michigan many times. So mother even recognized the fact that Michigan could be the proper court and filed a divorce in Michigan, but never went forward with it, and it was eventually dismissed for lack of prosecution. So mother was in Michigan with the children. There was no substantial ties to Tennessee, and this is basically a pass-through case. We have an immigrant who came to America, did not come to Tennessee. She went to, I believe, Delaware, stayed there for a period of time, passes through Tennessee for a mere couple of months, and then goes to Michigan, where she intended, I believe, to live the whole time with her family, and then was in Michigan and is still in Michigan. And father's also in Michigan at this time. And father was in Michigan at the time of the final decree of divorce. So I believe there was no substantial ties to Tennessee. Tennessee had no, bone in the fight. Everything was in Michigan. Mother had filed a divorce in Michigan. The witnesses were in Michigan. The children went to school in Michigan. The children were seeing a psychologist in Michigan. Everything was in Michigan. I don't dispute that the court probably still had jurisdiction over the divorce itself and had the right to grant the divorce because that jurisdiction continued because everything was filed in Tennessee. And the further argument that the parties consented to jurisdiction in Tennessee, I believe is well established. Parties cannot consent to jurisdiction if jurisdiction does not exist.
Let me make sure I'm clear about what you just argued, Mr. Mikulec. So you agree that in connection with the divorce itself, the court had jurisdiction to grant a divorce?
Yes.
Okay.
But not over the children because the children follow a different rule. And the fact that the parties consented is irrelevant. The Tennessee courts have a long line of cases where parties have done divorces by mail to other states. Neither party went in that state, and they say that you either have jurisdiction or you're not. You cannot consent to jurisdiction.
The divorce itself, jurisdiction was met because your client had lived here for more than 6 months before he commenced the divorce.
Correct. Even though the divorce was granted on the counter complaint, and the counter complainant had not lived in Tennessee for 6 months.
Well, however, that doesn't matter, does it?
That's why I didn't argue that. I'm just bringing it up.
All right.
Okay. And then getting off this, I only have 2 minutes left. On the attorney's fees argument, I would state that the court never made an analysis of the defendant's ability to pay, that the court awarded attorney's fees of $15,000 without having a substantive hearing on that issue. The affidavits to support the argument of the attorney's fees were notarized 5 days after the final hearing, and there was no way the court could have looked at those. They weren't even filed for 5 days. The only evidence of my client's income was $1,800 a month in a previous child support hearing, yet attorney's fees of $15,000 were awarded on top of everything else, and there's just no way he can afford those, and there was no analysis done of ability to pay. And then the issue of the $20,000 award for a loan allegedly made by wife was never pled, was first brought up at the final hearing. No evidence of that loan was ever introduced to the court other than the testimony of the mother that the husband loaned her money while they were married, and somehow an award of $20,000 was granted on a loan that was made during the marriage to a spouse with no evidence of the loan, without being pled or brought up until the final hearing. So I believe that was not properly pled, was outside the pleadings according to Qualls, and that should not be sustained because father had no way of effectively defending against that and had no knowledge of it until the final hearing.
Did you object when that was introduced?
I made an objection at the end, at the close of the proof at the default judgment hearing, which I was not given notice of, which I was never informed that the hearing was going to exist.
Wait. Excuse me.
I'm sorry.
When the evidence of the loan or the testimony of the wife as to the loan was introduced to the trial court, did you object at that time?
I objected to the award. At the end of the close of the proof, I objected that it was improperly brought before the court.
Was that the same hearing?
Same hearing. At the end of the hearing, I objected that it was improperly brought before the court because it was not pled.
Okay, thank you. And you used your time. We will hear from the, I think the appellants.
Good morning, Your Honors.
Morning.
Al-Sulaihi from Memphis, Tennessee, and I will address the court very briefly on the issue, of the default judgment. Rule 55.01 of the Tennessee Rules of Civil Procedure provides that when judgment is sought against a party that has failed to either plead or otherwise defend, and such can be shown by affidavit or otherwise, default judgment may be entered. In this particular case, while it is true that the husband's attorney in the proceedings below never did in fact file an answer to the counter-complaint that was filed on behalf of the wife, he did in fact actively participate in virtually all aspects of the litigation, both before the filing of the counter-complaint, following the filing of the counter-complaint, and prior to the motion for the default judgment. In May of 2018, he participated in a hearing regarding the production of documents and the issue of removal of the children from the United States, and signed off on the order that arose from that hearing. In mid-October of that year, he participated in a hearing predicated upon a petition that he had filed with regard to parental relocation. He participated in that hearing and signed off on the order that was issued following that hearing. As noted in appellant's brief, quote, and I'm quoting, "The default judgment protects a diligent party from delay and uncertainty as to his rights." In this particular case, there is no evidence whatsoever that that the proceedings were unduly delayed by the actions of my client's attorney.
Well, what was the basis for the entry of the default judgment?
The basis for the entry of the default judgment was a failure by the attorney. The basis for the entry of the default judgment was a motion by the husband's attorney to withdraw from the case on the grounds of quote unquote lack of cooperation. At the same time, based upon the actions of the attorney throughout the course of these proceedings, It does not appear that there was any lack of cooperation as between a client and attorney, because the attorney participated in all aspects of the litigation.
Okay.
Otherwise, I would simply end by saying that nothing in the husband's actions in any way caused any delay, undue or otherwise. And if there were delays in the proceedings below, they are equally, the fault for such delays are at worst equally shared by the parties. Thank you.
Thank you. And we will hear from the appellee. You may proceed.
Good morning, Your Honor. I was waiting for the time to show up. Michelle
Okay.
Crawford. I'm Michelle Crawford. I'm from the Shelby County Bar. I wanted to first address the UCC JEA argument that Mr. Mikowitz has made on behalf of his client. At the time that the divorce was filed, jurisdiction lied in Tennessee. As we know, jurisdiction attaches at the commencement of the proceeding and continues to remain throughout the entire proceeding. At the time that Mr. Alzamzami filed the complaint for the divorce, there was no home state for these children. They had only been in the United States for 4 months. And as a result, you had to go to the second prong of the UCC JEA and look at whether there was significant connections and evidence regarding the child's protection, training, and relationships in the state of Tennessee. And the state of Tennessee, at the time that the divorce was filed, the children had been living here for 4 months and they had gone to school here. There was evidence in the record that they had gone to the doctor here. And there was also evidence in the record regarding the police being called to the marital home that the children witnessed and domestic violence issues. So as a result, Tennessee did accept jurisdiction of the initial custody determination. And whether they continued to have jurisdiction, that argument was made in the motion to dismiss, and the court determined that they were the only court at the time that the motion to dismiss was filed that could exercise jurisdiction over the children. There was nothing pending in any other state, including Michigan, to transfer jurisdiction to, and the court had previously heard testimony from the parties as well as the children regarding the children's welfare, and they were the only court in a position to make a permanent order. There's a two-way argument on that, is whether the temporary order was an initial custody determination, and if it was, then it is Ms. Al-Sulaihi's position that they continue to have jurisdiction based under the UCC JEA, or in the alternative, because it was a temporary order under the UCC JEA, they did have the jurisdiction because the significant connections and the children's evidence attached at the time that the divorce was filed. The next argument that Mr. Mikowitz made was the final decree as it relates to the affidavit submitted for attorney's fees. The final decree of divorce was entered after the affidavits of attorney's fees were submitted. Ms. Al-Sulaihi did testify regarding the attorney's fees at the final hearing, at which time the court requested the attorneys for Ms. Al-Sulaihi submit affidavits for the court to review. The court reviewed those affidavits prior to entering the final decree of divorce.
Was the attorney fee issue contested in the trial court?
No, Your Honor. Mr. Mikowitz and his client both participated at the final hearing, as the statement of the evidence shows that was submitted to the Court of Appeals in the record. They did not cross-examine any of the witnesses, although they had the opportunity to do so. Additionally, I know that Mr. Mikowitz indicated that he objected to the testimony regarding the loan. That objection was only made after the court had awarded Ms. Al-Sulaihi a judgment in the amount of $20,000 for repayment of the loan. There was no objection made during the time when Ms. Al-Sulaihi was testifying. There was no questions to Ms. Al-Sulaihi regarding this loan on cross-examination. Her brother also testified to this loan. And so the loan and its existence was undisputed. Mr. Alzamzami participated in that hearing. He was present and no objection was made, Your Honor.
You say
And
in the statement of the evidence, is that distinction made as to when the objection was raised?
I believe so, Your Honor. I'd have to go back and look, and I do not have the statement of the evidence in front of me, but I believe it says after the courts awarded the loan amount, that is when Mr. Mikowitz raised the issue, and the court determined that testimony was proper. Ms. Al-Sulaihi testified to it. She was not questioned about it on cross-examination, and therefore it was undisputed. I'm also going to go over the not setting aside the default judgment. The timeline of this case is Mr. Alzamzami filed his complaint for divorce in February of 2018. The initial hearing regarding the temporary issue of relocation and custody was heard in October of 2018. In December of 2018, consent orders were entered regarding child support figures. Those consent orders also included the income of the parties. In July of 2019, there were motion hearings on wage assignment issues. So there was participation by all parties for a year after Ms. Al-Sulaihi had filed her counter complaint. Ms. Al-Sulaihi, in an attempt to get the case resolved, also filed a complaint for divorce in Michigan, which also had jurisdiction over divorce. She attempted to serve Mr. Alzamzami, and that service, she could not get service completed on him. As a result, that case was dismissed. She switched counsel in May of 2020 and hired our office, which is when we filed a notice of appearance. At that time, we filed the motion for default judgment because an answer had not been filed in over 2 years, in almost 2 years. Mr. Alzamzami's attorney at the time, Mr. Bostic, then filed a motion to withdraw. There was a hearing that was held on both of those motions. Our motion for default was granted first, and then Mr. Bostic was permitted to withdraw as Mr. Alzamzami's attorney. And the basis for that withdrawal was his inability to be able to effectively communicate and cooperate and get cooperation from his client. The court did order.
Let me ask you a question here about the default judgment. So the only reason the court granted the default judgment was because an answer had not been filed.
Correct. And Mr. Bostic indicated that he could not get any cooperation from his client, and the case had been dormant for a year, over a year, almost a year.
And so what is the significance at that point in time of the default judgment?
For us to be able to proceed in obtaining the divorce for the parties.
Okay, was the divorce the only thing that the default judgment was rendered on?
I believe so, Your Honor, because Mr. Alzamzami's complaint was also still pending at this time. The default judgment was granted on the counter complaint of Ms. Al-Sulaihi. So everything contained within the counter complaint, which included a request for the division of marital assets and debts and for custody of the children.
Okay, so the only thing that really the default judgment did was say that a divorce is granted.
The default judgment, yes, granted her a divorce and allowed her to proceed for the hearing on September 23rd on the uncontested docket. But Mr. Alzamzami's complaint for divorce was still pending at that time.
Okay.
So the court granted the default judgment. The court also granted Mr. Bostic's motion to withdraw and advised Mr. Bostic, which his order shows, to notify his client of a status conference, which was held June 8th. At that status conference, the court advised Mr. Alzamzami, who participated, that there were certain deadlines in place pursuant to our rules of civil procedure, and those deadlines would need to be followed. And they also gave him until June 15th to hire counsel. He hired Mr. Mikowitz on June 12th. At this time, the default judgment is still not a final order. 30 days had not passed at the time that Mr. Mikowitz was hired. There was another status conference on June 15th that Mr. Mikowitz participated in, in which the court again reminded Mr. Mikowitz that there was a default judgment currently in place, and that was going to be a final order after 30 days. And that if his client would need to take the proper steps to set that aside. That was still,
So it's your position that if a default judgment is rendered, even though the case is still going on, that it becomes final after 30 days?
yes, Your Honor, that it would become a final judgment after 30 days. And if Mr. Mikowitz wanted to set it aside, he would need to do it pursuant to, like his motion indicated, pursuant to 6002 or pursuant to a Rule 60. But
why is that, since a default judgment is still interlocutory, since the case is still going on?
he could have filed an interlocutory appeal on the default judgment, Your Honor.
You misunderstand my question.
I'm sorry.
The case itself is continuing. The
Correct.
issues of custody, of property division. The only thing that had been determined, as I understand it, was the entitlement to a divorce. And I'm assuming that had not been certified under Rule 54.02, had it?
No, Your Honor.
So why was that not an interlocutory order that the court could revise at any time, no matter whether 30 days had passed or not?
I think the court could have, and Mr. Mikowitz filed a motion to set it aside. He could have filed a motion to alter or amend, and the court deemed that there was not, at the court's discretion, that there was not a basis to do it under Rule 60 and under Rule 55.
So
she denied that motion.
So what was the basis for the court not setting aside the default judgment?
Due to the actions of the plaintiff in his delays, that he was well aware of what was going on in the case. I think in part due to the motion filed by Mr. Bostic that his client was not cooperating, and that the case had been laying dormant for a long time. The court was wanting the case to proceed forward.
I understand the case had a lengthy history to it, but besides the fact that the case, it had taken some period of time for it to be resolved or get to the point to be resolved, what other evidence did the court have before it on this this motion to set aside the default?
I'm not sure I understand your question, Your Honor. What evidence relating to what?
To you just mentioned why the court did not set aside the default judgment. And you said that it was delay, essentially, some statement by, and I'm assuming his former attorney was not under oath when he made those statements about difficulty with his client cooperating. So those are just statements of counsel. So what's the evidence the court had in front of it?
Well, that's the other problem, Your Honor, is when they filed the motion to set aside the default judgment, no affidavits were submitted by Mr. Alzamzami as to why the court should set aside the default judgment. There was no clear and convincing evidence submitted by Alzamzami of his attempts to participate in the litigation. And I believe that the case law requires, in order for the default judgment to set aside, there has to be clear and convincing evidence. And Mr. Alzamzami provided no affidavits for him on his actions, on anything that he attempted to do. And there were no affidavits provided by his counsel or prior counsel on their steps to participate in the litigation. I'm
assuming you didn't submit any affidavits either.
I did not, Your Honor.
Okay. You may proceed.
Thank you, Your Honor. I believe I have addressed all of these issues that Mr. Mikowitz brought up. Are there any other questions for me at this time?
Yeah, well, let me be clear. When did your client move to Tennessee, and when did your client leave Tennessee?
Okay. Ms. Al-Sulaihi moved to Tennessee in November of 2018. She left Tennessee in February of 2018. The divorce was filed by Mr. Alzamzami in February of 2019, or I'm sorry, 2018.
So she
November of 2017 is when she moved.
Okay.
February of 2018 is when she left Tennessee. So she was here for 4 months. Mr. Alzamzami chose to file the divorce in Tennessee. And that is where the court determined that they had jurisdiction over the children because there was no home state for the children at the time the divorce was filed. And the children had gone to the doctor in Tennessee, had gone to school in Tennessee, and there were the domestic violence issues that also occurred in Tennessee at the marital residence.
But all of that would occur before February of 2018. Is that correct?
Yes, Your Honor. All those things occurred between November of 2017 and February 2018 when the divorce was filed.
So at the time of the hearing in October 2018, your client was not here, nor was the children here in Tennessee. Is that right?
That is correct, Your Honor, but nothing was pending in any other state at that time either.
Okay.
Okay, thank you.
Thank you.
Let's see, I believe we have 2 minutes of rebuttal time for the appellant.
Yes, Your Honor. I'd just like to point out what was just mentioned by opposing counsel. This matter was set on the uncontested docket. I was not given notice of the hearing, the final hearing. The only reason I knew to appear was I just happened to look at the court's calendar for the week and saw that it was set. I had no ability to call witnesses. I had no ability to subpoena witnesses. It was not set for a hearing. It was set for an uncontested divorce. As stated a number of times in the appellee's brief, because a default judgment was granted, I did not have a right to participate. I objected to damages, which I believe, had a right to. I was never given an opportunity to call witnesses. I was never asked by the court, would you like to question this witness? Because it was an uncontested divorce. I was not given the right to participate. That, and on page 31 of the appellee's brief, it's clearly stated I did not have a right to participate. If I was allowed to participate, I should have been given notice of the hearing, which I was not given. Sorry.
At the time of the hearing that you're referring to, your client still had a complaint for divorce pending. Is that correct?
Yes, but that was not set that day. Only the uncontested divorce of the counter complaint was set on that day.
I understand that, Mr. Mikowitz. Had you ever set any type of hearing on your client's complaint for divorce?
No, because everything moved so fast. Once a default judgment was granted, the hearing was set immediately. I mean, once I was denied my motion to dismiss, they immediately set the default judgment hearing for uncontested divorce.
At that hearing, did you attempt to ask questions and then you were cut off by the trial judge?
At one time, the judge said, Mr. Mikowitz, oh, never mind, call your next witness. that was my, and then when it was over, I objected to the various things that I could object to. I was not given an opportunity to ask questions.
All right, thank you for your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. We again appreciate you participating in this oral argument via Zoom. Ms. Tibner, anything further before we recess court to the call of the next case?
I know, Your Honor.
You may recess court then.
This honorable court is now in recess until 10 a.m.
Thank you for consideration, Judge.
Thank you.
You can leave